Today is May 13th, 2026. Exactly 1 year from now, the clock runs out on India's data privacy grace period. Barring unforeseen delays, the Digital Personal Data Protection Act, the DPDPA, is targeted for full implementation on May 13th, 2027. On that date, the state begins imposing financial penalties for non-compliance. But data privacy officers are currently navigating a paradox. Two conflicting operational forces are peaking today, pulling corporate strategy in opposite directions. The first force is the legal track. Right now, the Supreme Court is hearing a fundamental constitutional challenge aimed directly at the law's validity. Simultaneously, the second force is moving in the background. The administrative track is actively accelerating, building out the state machinery required to enforce the act. This creates a trap for the private sector. Companies choosing to pause their compliance architecture while waiting for a final verdict from the court risk missing hard, unyielding administrative deadlines. An effective strategy requires decoupling these two events. You must separate the legal risk vector from the executive rollout timeline. To build a realistic roadmap, we have to calculate the probability of the judicial threat and then map the actual speed of the state's execution timeline. The legal battlefield is currently defined by a cluster of public interest litigations. A battery of well-known PIL lawyers have brought these challenges to the court, representing groups of journalists and activists. The friction driving these challenges is an apparent conflict in rights. Petitioners argue strict data protection scopes severely limit the public's right to information. However, the law is not standing undefended in the courtroom. Organized industry advocates have mobilized to maintain the regulatory framework. The Foundation of Data Protection Professionals in India, the FDPPI, has filed an intervention petition to support the DPDPA. Their objective isn't maximizing conflict, but assisting the court in charting a harmonious resolution, satisfying both the right to privacy and right to information. The proceedings indicate a search for regulatory balance rather than an attempt to tear down the entire digital governance structure. This probability model charts the potential rulings the Supreme Court might deliver, shifting our focus from courtroom arguments to statistical reality. The first potential outcome is the DPDPA is scrapped entirely. While it remains a technical possibility, the total scrapping of the act is the lowest probability path available to the court. The far more realistic outcome is a reading down of the law. A reading down preserves the law's core purpose while narrowing its application, softening or reinterpreting specific peripheral clauses that create constitutional friction. Because the current agitation is centered specifically on RTI and journalism, any judicial corrections will likely be surgical, adjusting specific exemptions for those groups, while leaving the standard technical obligations for the rest of the industry unchanged. Because a total repeal is so unlikely, the private sector must treat the law as a permanent reality and pivot its focus to the speed of the executive implementation track. The administrative machinery is moving forward at high velocity. This timeline tracks the first critical dependency for enforcement, seating the Data Protection Board, or DPB. The government has finalized search committees and issued public calls for DPB member applications. The window for receiving these applications closes June 5, 2026. This tight deadline signals an uncompromising posture from the state regarding its deployment schedule. Based on this schedule, candidate selections will be finalized by the end of June. Following selections, the Data Protection Board should be fully seated and operational by the end of July. Within 60 to 90 days, India's primary data enforcement body will exist in reality, complete with the personnel required to take regulatory action. This rapid human infrastructure deployment makes one thing clear: the government isn't waiting for the Supreme Court's permission to build its enforcement arm. Beyond the personnel, we have to track the technical architecture required to actually process regulatory data. Significant development on this front has already been completed in the background by the National E-Governance Division. This architecture map shows the digital office of the DPB, the primary instrument for implementing the law. This digital-first design ensures regulatory interfacing between the state and private entities is automated. The most critical interface point for the private sector involves organizations acting as consent managers. The first unavoidable action point for these entities hits on November 13, 2026. On this date, the DPB will officially begin receiving applications from organizations intending to register to manage user consent. To submit an application by that date, an organization's internal compliance framework and technical architecture must already be finalized. For key industry players, November 13, 2026 is the true start of operational compliance. Waiting for the May 2027 penalty date is a deceptive strategy. We return to the tension between judicial risk and administrative velocity. A reading down by the Supreme Court will adjust the specific parameters of the regulatory machine, but it will not stop the machine from turning on. The background work completed by the e-governance division, combined with the fast-tracked DTB search committees, proves the state's infrastructure is already locking into place. Relying on the May 2027 enforcement date as your primary target for compliance engineering ensures you will fall behind. Industry operators, especially potential consent managers, must align their internal readiness to the November 2026 submission window. The operational countdown is active. The critical dependencies are already